Hello, this is Laws 11049, Environmental Law. John Milburn, this is week 3 in term 1 of 2014. In week 3, we're dealing with the executive branch of the legal system. Before we start, an exam tip and also a study guide tip. The material in the module the study guide module material is of extremely high standard, but it is pitched at a level that I think is fairly high, and I don't want to discourage you in your studies, so I'm asking you to primarily work with the textbooks, or the textbooks rather, and if you have any problems with that, let me know. By all means, however, continue to read the study guide material, but don't let it discourage you from reading on. It's written to a high level, and in some ways a very theoretical level. In terms of an exam tip, what I like to see is sentences that are short and quite well constructed. I'm very much opposed to the formal legal style of writing, which is very long and involved sentences. I'm a fan of short, sharp sentences that encourage the reader to go on and read more, and also are very readable and interesting. So if, when I'm marking your examination material, I believe that the sentence is too long, you will not be rewarded for that, if I can use that term. But if you're using short, sharp sentences, you're making it readable, you're writing the material to as if someone has no knowledge of the subject, then you will be rewarded for that. All right, and if you have any questions as we go, please stop me. And by all means, for those of you who are participating live, please use the chat function as much as possible. If you do want to speak, just disengage your microphone. Otherwise, perhaps I'd ask you to put it on mute as we go. All right, now, study guide 3, week 3 is all about the executive branch of the legal system. This is Bates chapter 2 primarily, and also study guide module 3. I want to talk firstly about the concept of terra nullius. And if you want to follow along, I'll guide you through Bates as we go. So this is 2.2. After settlement, says Bates, Australia inherited the existing common law and legislation of the United Kingdom. Now, that was possible because Australia was deemed to be terra nullius, that is, unoccupied land. The British declared Australia to be empty land, and as a result there was no treaty with Indigenous Australians that was seen as being unnecessary. In essence, the British said that there was no sovereignty held by the Indigenous Australians which was capable of being relinquished to the British. In 1992, the High Court of Australia finally overturned the doctrine of terra nullius in what is a dramatic piece of judicial activism, which is where the courts effectively make law. In Mabo against Queensland, number 2, which is cited as 1992 175 CLR, which is Commonwealth Law Reports, number 1, the High Court considered a claim brought by Eddie Mabo on behalf of the Meriam people. The Meriam people had occupied the Murray Islands in the Torres Strait between Australia and New Guinea since well before British settlement. In 1985, the Queensland government had sought to resolve uncertainty about the state's ownership of the islands by enacting the Queensland Coast Islands Declaratory Act. This act sought to abolish any claims to ownership of the islands by the Murray Islanders. 3 islanders, including Mabo himself, commenced a legal action challenging the validity of the Act, arguing that it was contrary to the Racial Discrimination Act, which was a Commonwealth Act from 1975, and therefore it was invalid under Section 109 of the Constitution. I'd better stop there and explain that. So firstly, we have the Racial Discrimination Act of 1975 that was brought in by the Commonwealth pursuant to its powers to make laws to that effect. Mabo and others sought to overturn the Queensland legislation on the basis that it breached the Commonwealth legislation, the Racial Discrimination Act. If you have a conflict between a Commonwealth law and a state law, then Section 109 of the Constitution comes into play. And essentially that section says that where there is a dispute, a clear dispute, then the Commonwealth law will prevail. So what Mabo needed to establish is that the law which had been introduced by the Queensland government was contrary to the federal law and therefore invalid under Section 109 of the Constitution. In that case, as we all know, the Islanders were successful. In order to prevent attempts by the Queensland government to abolish any possible title by the Islanders, a legal action was brought by the Mabo people before the High Court in order to have the rights of the Meriam people formally declared. Again, I'll just stop and explain what we mean by declared in a legal sense. At law, some courts, some tribunals have power to make declarations. And a declaration is a statement that a certain fact will become the law or will become the legal position. A declaration is a statement, as in this instance, that the Meriam people did have lawful ownership of the islands in the territory in the Murray Islands. And that's a declaration. It's not saying that one party owes money to another party, which is, say, a damages claim. It's a declaration as to what the legal position is in a particular instance. In doing so, the High Court had to come to the conclusion.
Sorry,
that,
John.
Yes.
One thing that about this, you mentioned, and I'm just going to put your ask about it now because it's something you said right at the beginning. In regards to judicial activism, you said the court made the law. Now, I thought that that was not possible, you know, with this three-tiered system that we have.
No, it is. It is actually possible, and that's a really good question. And I wanted to stop there and sort of emphasise that to demonstrate that point. In our three-tier system of government, we have the legislature, and that makes legislation. It makes acts of Parliament, both Commonwealth and state. The executive, which also in a way creates laws by the way it interprets and administers the acts in a practical sense. And then we have the judiciary, through common law, can create new law. Now, the way in which common law is creating new law is that usually it's done by interpreting existing legislation. For example, I'll take a very simple case. If the Act simply said that if you're driving a motor vehicle, you're not allowed to speed and went no further, then it would be an offence to speed. However, if someone was prosecuted for allegedly speeding, they may challenge that on the basis that the speed that they were doing, which was 60 kilometres per hour, was not in excess of the was not speeding. Now, I'm assuming for the moment there are no, there are no speed indications or no other laws at all. There's no traffic signs indicating speed. So the court in that instance, in that very simple instance, would have to determine what is speeding and what is not speeding. And as a result of the cases which are decided on that point, the body of common law is built up. And in many ways, it supplements the legislation. In many ways, it explains the legislation so that people have a better understanding. But it's still creating law. So the courts are still creating law because what the courts have decided will generally be relied upon or must be relied upon by various other courts in the future. So the common law, the judge-made law, in a way, is a way of creating law as well as Parliament creating law through legislation. When we talk about judicial activism, we're really talking about a bold new step, which is quasi law, quasi-act, if you like, if I can use that term. So it's where the judiciary takes a very bold step. And there was no legislation that declared Australia terra nullius. So in a sense, there was a void. And the High Court in that decision of Mabo filled the void by declaring that Australia is not terra nullius. So because of the significance, we call that judicial activism. Sorry, that was a very long answer to a simple question, Nikki. Did it answer it adequately?
It did. I was just thrown by because that's made it a little bit clearer for me, because as I was reading there were these 3 tiers and that was basically how it sat. So
Okay.
That's good to know. Yeah, thank you.
All right, thank you. All right, so the High Court made this declaration, and it said that the previous view that Australia was terra nullius at the time of British settlement was in fact wrong. In this instance, because of the continuous and ongoing connection and occupation, the Marian people did have traditional title to the Murray Islands, and this survived the British settlement. Other Indigenous Australians in a similar position could also claim traditional title and traditional rights, and that could be not be taken away by express laws to that effect. So that's where we have this introduction of effectively new law created by the High Court. The High Court's decision led to recognition of common law of native title in Australia. However, in order to be very clear on this point, the Commonwealth Government did, the following year in 1993, pass the Native Title Act, and as a result of that, it created legislation which made it very clear that what had been created through judicial activism would continue, but this time in a legislative framework. So the Native Title Act was passed, and the Act established that the existence of native title on particular land was available to Indigenous Australians if they could establish their claim in accordance with the terms of the Act. It did, however, validate past Commonwealth action in making land grants inconsistent with property rights of Indigenous Australians in some ways. The follow-on to the decision in Mabo was the decision in in the Wick Peoples against the state of Queensland, and that sparked considerable controversy when the court decided that the grant of a pastoral lease did not necessarily extinguish title. If I refer you to Bates at 2.11, the comment is made as follows. Any finding of the continuous existence of native title is significant to environmental law because of the different regimes that may be applied to the management of land and its natural resources by Aboriginal land holders. He goes on to say in 2.12, because of the extent to which the Crown has interfered in land and natural resource management over decades, it is notoriously difficult to establish continuing native title, particularly exclusive title. If I could now just go to 2.13, a few paragraphs from the top. It does talk about the Nature Conservation Act of 1992. It's Queensland, and in that act, the Queensland government declared that property in natural and cultural resources in protected areas and in protected animals and plants lies with the state. Now I'm going to backtrack here.
John, how does that work then with the EPBC Act if it's a protected, nationally protected animal?
That's right. Look, the EPBC Act and the Nature Conservation Act can often work in tandem, and as we've indicated, where there is a conflict, Section 109 would say that the Commonwealth legislation, EPBC, does, and that's the Environment Protection and Biodiversity Conservation Act of 1999, that will prevail. But there are different circumstances where the different acts will apply. I had an instance last year where I was defending a client who'd been charged for a breach of environmental legislation, and that was a quasi-criminal prosecution. And in that instance, the Crown chose to prosecute under the Nature Conservation Act, but arguably they could have prosecuted under either act. We see that in many instances where there's Commonwealth law and state law, a choice can be made, or alternatively, the prosecution can be in relation to both matters. Thanks, Nikki. I just want to go back to, sorry, 2.3, and I know I'm jumping around a bit, but on page 22 in Bates, there's a statement made that the purpose of the common law is first and foremost to recognise and protect interests in private property. We've discussed common law, and in essence that's judge-made law. At university in the 1970s, when I was studying, as I indicated last week, there was no environmental law as such, but they were framed under different headings, what became aspects of environmental law. For example, under the law of torts, which is TORTS, there are claims of negligence and nuisance, which have a quasi-environmental law flavour to them. Now, at 2.4, Bates says, when framing environmental policy and translating that policy into law, it is frequently necessary to confront the long-held notion that ownership of land carries with it the right of the landowner to do whatever he or she wishes on that land. Further down, environmental legislation has been introduced precisely because of the inability or reluctance of the common law to effectively recognise the environmental values of land as distinct from its property values. So that's progressive sort of thinking. And in a way, what the author is doing there is criticising the judiciary collectively for failing to implement judicial activism in the field of environmental law. At least arguably, that's what's being done. Now, if we could talk about, we've discussed briefly the separation of powers. 2.5, there is a commentary in that regard. So I'd pay particular attention to anything to do with the doctrine of separation of powers. Now, 2.5, effective parliamentary democracy depends on a separation of functions between the powers of the legislature, the parliament, the executive or the administration, the government agencies, and the judiciary, the courts. Now, does everyone have a fair idea of what we mean by those three different aspects? Does anyone have a question about the separation of powers generally? Or is it all pretty easy to follow?
Only one in regards to the executive.
Yeah.
Yeah.
So that's state as well as, so, well, you know, like bodies, I guess, for want of a different word, but it's also the police, that's correct?
Yes, police do have an executive function.
Okay.
So, yes, government agencies generally.
That's criminal more than, I guess, nuisance or trespass.
Yes.
But, I'm trying to work out where they fit in. You know, I assume they're executive, their role, is it?
That's right. It's an executive function that the police would fulfil. They have that administrative function. All right, so Bates goes on to say, in our system of governance, therefore Parliament makes the law, the executive implements the law, and the judiciary enforces the law. Although some positions, such as Member of Parliament, who is also a minister, have foot in two camps, the functions of that person in each case are clearly defined. It is sometimes not clear as to what constitutes a legally binding document. That is certainly in the case in relation to documents created by the executive, but it might also be in relation to environmental legislation. Now, to explain that, perhaps if I go to 2.5, sorry for jumping around again. For those of you who have the text, at 2.50, sorry, I said 2.5, but I meant 2.50, which is on page 47, Bates says, although guidelines, codes of practice, practice and advisory notes, and most types of policies are generally not sources of law, there are exceptions, and environmental legislation must be scrutinised to understand the legal status of the instruments being created. So questions there are, for example, codes of practice, for example, at law, merely aspirational rather than legally binding. In the case of Van Son against Forestry, Commission of New South Wales, 1995, 86 LG-ERA 108, is instructive, and that's where a forestry code of practice was held by the court to be aspirational rather than necessarily legally binding. In environmental law, we seem to have more of these things.
Hi, John. Sorry.
Hi. Yes, Lawrence.
I was just wondering, a license, that is a statutory binding, is that a license?
A license?
Yeah.
Lawrence, I'm getting a lot of feedback.
Okay.
Sorry. Thank you. Just when your microphone's on, I'm getting some feedback on it. Now, I think the question is what is the legal effect of a license? Essentially, a license is an administrative or is conferred upon a person as a result of administrative function, which is the executive, and it does have legal status, but it doesn't have operation as a result of legislation, generally speaking. It would be very rare for that to occur as a result of legislation, but it would be part of the administrative function exercised by the executive. Thank you, Lawrence.
One thing that I found interesting in regards to license, John, in the book, it said something along the lines of like licenses in theory can't be on-sold.
Yes, very often that's the case.
But if you've got something like a water license,
yep,
that certainly can be. So is that an exception that's come about, or is that had to go through some process to change from executive up to legislative?
Yeah, generally speaking, they're all executive, but they're not necessarily all the same. And it is a case of considering each one as it appears. Very often that is the case, that the licenses are non-transferable. That creates difficulties for people, for example, in the tourism industry or the fishing industry, in instances where they've got a considerable business which is reliant upon the existence of a license, and that's non-transferable. So it makes it difficult to sell that business. One way that we get round it in practice is make a contract subject to the granting of a fresh license in favour of the purchaser as a condition of sale, and if that occurs, then the business will proceed. But it is a matter of checking what it is in each instance. I guess a parallel that comes to mind is that previously it was the case that Commonwealth and state governments, I think it's fair to say, would employ on a full-time basis employees far more readily than putting them on contracts. We've seen progressively over a period of years that emphasis has changed considerably, and now governments are more inclined to engage people, certainly in more senior roles, on a contract basis rather than a permanent full-time basis with tenure. And it's a bit like that with the licenses. There's no rule that says it must be one or the other, but it's a case of determining what it is in that particular instance. So thank you, Nikki. Any other questions before we proceed? All right, well, if we could have a look at the chapter, the heading on page 29, Overcoming Private Rights, Compensation for Acquisitions of Property, Now, I think this is a really fascinating area of practice. The comment is made that translating environmental policy into environmental law inevitably means overcoming rules of common law that landowners should be free to exercise their proprietary rights within the boundaries of their own property. At 2.16, the Commonwealth Constitution clearly stipulates that laws of the Commonwealth that affect an acquisition of property must do so on just terms. And I love saying that term because it reminds me of The Castle, and I'm sure you've all seen The Castle, the movie. And if you haven't, I'm sure you definitely should. But anyway, let's see what all that means. Firstly, I make the comment that courts will not interfere, will not interpret statutes as meaning that property rights are modified or removed without clear words. Then we have the constitutional statement that if there is an acquisition of property, it must be done on just terms, and that's section 51, Roman numeral 31. Can I just stop there again? If you're not familiar with the Constitution, I would urge you to become at least familiar with parts of it. And we talk about the Commonwealth of Australia Constitution Act, but really what we mean by that is the Constitution. And section 51 is the section which confers upon the Commonwealth power to make laws in relation to the named areas. And in this instance, section 31 says that the Commonwealth must provide compensation for acquisitions on just terms. Now, if I could just proceed. The first task, this is at 2.16, is to characterise the nature of the entitlement being acquired as property. The concept of property denotes a sense of permanence and security, by contrast to a licence, which is revocable at any time. Referring to paragraph 2.18, there is the decision of Environmental Protection Authority against Rashley, 2005 ACTA CA 42. I'll just ask you to notice one thing. In reading that case, I said against, the EPA against Rashley. It's not appropriate to say the word versus. So it's a trap for non-lawyers. So at law, we say EPA, and I've shortened it, v Rashley, or EPA against Rashley. But you wouldn't say EPA versus Rashley. Not in Australia anyway. Okay, so in that case, the court said, the Court of Appeal reversed an earlier decision and established that an owner or lessee of land, while they have right to access water flowing below that land, does not have property in the water. In other words, a restriction imposed by a regulatory regime, in this case a licensing regime, would not amount to an acquisition even if the license was refused. Now, in some ways we're playing with words here, aren't we? Because if you have a water license, then arguably in many instances you have something which is very valuable. If that license is taken from you, the question is, has the government made an acquisition of something from you by denying you that license into the future? In which case, the Commonwealth Constitution would say that the government would have to do that on just terms. So that's the dispute. Does anyone understand, or is anyone having trouble with the concept of what I'm trying to say here, which is trying to better define the concept of property?
Yeah, I definitely am. And I found this similar thing in, I can't remember offhand where it is, the Oyster case as well too. I struggled with that decision as well and how that was worded and set out.
Okay, thank you for that, Nikki. Anyone else having difficulties? Yes, I'm getting a few nods as well. Okay. Well, look, let's see if we can, we'll move on and we'll see if it can, we can clarify it. The approach of the Australian Capital Territory Court of Appeal in Rashley has effectively been confirmed by the High Court in ICM Agriculture against the Commonwealth, which is 2009, HCA, which is High Court of Australia, 51. The 51 means it was the 51st case reported from the High Court in 2009. In this case, the majority of the court held that a reduction in volume of water allocated by aquifer licences, which had replaced old-style bore licences, did not amount to an acquisition of property. There can be no acquisition unless some identifiable and measurable advantage is derived by another from or in consequence of the replacement of the plaintiff's licence or reduction of their entitlement. The plaintiff's rights under the bore licence did not return to the state. Upon cancellation of the licence, the state gained no larger or different right. So we have two cases, Rashley and ICM, where the ACT and the High Court, respectively, have indicated that the mere failure to provide a licence or renew a licence perhaps is not an acquisition and therefore it is not compensable. Obviously, and of course with all due respect, I am troubled by that decision. It does seem to me that as a matter of logic, if one party has lost something of value, then someone else must have acquired that item of value. I don't know if there's any physicists there, but I don't know. It seems to me that if there's a loss one way, it must be, or maybe it's an accounting issue, I don't know. But it seems to me that if there's a loss to one, there might be a gain to another. The court didn't see it that way. At 2.20, Bates makes the following comment. The courts often see themselves as providing essential protection to the rights of the individual against overzealous use of government powers. Was the concern in this instance by the courts that a decision in the alternative would open the floodgates, as we say? That's a term that lawyers use, indicating that if a decision goes one way, then suddenly we're going to have a massive litigation opening the floodgates, as it were. 2.36, if I could move to that. Again, I apologise for moving around a bit, but this is the way it made sense to me when I was going through it. Second paragraph second sentence of the first paragraph. Environmental legislation, of course, now effectively makes natural resource management the business also of government, with a consequent potential to restrict access to and impose management restrictions on the economic use and development of those resources. While some intrusions into private property rights have been successfully made without compensation, most notably in the areas of land use or environmental planning and pollution control, it remains true that the most significant environmental problems facing Australia today have also proved to be the hardest for governments to tackle because they force regulators to confront the traditional rights of private landowners, and trying to effect change without compensation is politically very difficult. 2.40, Bates says, acquisitions of property are compensable by law. However, if mere restrictions on land use were compensable, then it would become either very expensive or practically impossible to implement policies and laws for environmental management. That brings me back to that concept of opening the floodgates. The fact that there are so many claims that might be made in certain circumstances that, notwithstanding the terms of the Constitution, and notwithstanding that landowners have suffered, in some instances, a great loss through policy and case law, we have situations where compensation is not paid. So I come back to my earlier statement about the floodgates. Providing compensation for restrictions is sometimes contrasted to a situation of encouraging investment through incentives. If I could take you to 2.42, governments have also introduced structural adjustment schemes to more directly compensate landowners for environmental restrictions, although some schemes have no legal imperative to provide just terms compensation. And you'll see there that there is a reference by Bates to ICM against the Commonwealth once again. In other words, what's being stated in that paragraph or that sentence at 2.42, the constitutional requirement to pay compensation for the acquisition of property does not apply when one considers the loss suffered by the landowner as the result of environmental restrictions. For example, in the case of licensing regime where the granting of the license was refused. That's just the legal principle that's been established now. In 2.42, Bates continues by reference to the case of Spencer against New South Wales Minister for Climate Change, Environment and Water, 2008, New South Wales SC, which is New South Wales Supreme Court, 1059. In that case, the plaintiff had been offered a structural adjustment payment to purchase his property, which was affected by restrictions on clearance of native vegetation. Justice Rothman could see how this was manifestly unfair to Mr. Spencer, given that the unfairness in this case is that the government had legislated in a way that renders the otherwise legitimate activities of Mr. Spencer to be such that they are no longer viable as a business. Having done that, government then offers to purchase the property at a value that is necessarily less than the value that could have been attained or obtained if the prohibition was not in force. If one takes an overall approach, then, there is no doubt that Mr. Spencer, says Justice Rothman, is under a special disadvantage. While all members of society must accept that there will be some restrictions on their activities for the greater good of society, when those restrictions prevent or prohibit a business activity that was hitherto legitimate because of the area in which it is operating, and assistance is often, which is not fully does not fully compensate for the restrictions imposed, society is asking Mr. Spencer and people in his position to pay for its benefit, says Justice Rothman. Now, in that case, we see a change of attitude from the judiciary. We're seeing some acknowledgement that as a result of the executive decisions that have been made in the licensing regime, it perhaps should be the case that affected persons are compensated. That type of thinking is contrary to the thinking of the High Court in ICM and the earlier case in Rashley in the ACT. So, what conclusions can we draw from that? Well, firstly, it is clear that governments are required by the Constitution, Section 51, Roman 31, to pay compensation on just terms when acquiring property. There is no such obligation imposed on government when it is not acquiring property. The failure to provide a licence is not regarded at law as acquiring property. The loss of value associated with a property, both in terms of capital and business opportunity on an ongoing basis, is not regarded as acquiring a property for environmental restrictions imposed upon the landowner or the lessee. So even though we have this sentiment by Justice Rothman, the law in that regard, through the High Court decision, does seem clear that there is no compensation payable as a general proposition. I know that's all pretty difficult. Are there any questions? Is anyone really having trouble taking that in? What I'd recommend is that you just try and stick with the general principles and cite the law and try not to fight it too hard. Okay. I'd like to talk about the influence of science. Now, for those of you who are scientists, and I'm clearly not a scientist, you might be a little bit more at home than I am in this regard, but it's 2.23, which is on page 32. Just a statement. Of all the influences that determine environmental policy, none is more compelling than science. Lawyers practicing in the field may well do well if they'd previously obtained qualifications in science. Conversely, scientists may therefore become highly regarded and valuable as lawyers because of their scientific background. And we often see specialist lawyers, barristers in particular, emerging as a result of their specialist knowledge in a particular area. And I've always suggested the analogy that if you were wanting to take on the tax department in a tax dispute, then the choice of barrister might be dictated by the fact that a particular person had previously worked at the Australian Tax Office and has an intimate knowledge of the workings of the opposition. And that would be an attractive trait for me in selecting a barrister. Likewise, if I was engaging a barrister to deal with an environmental issue which had a lot of science in it, I might be attracted as a solicitor to engage a barrister that does have a scientific background. So just keep that in mind. Also, can I say that I made the comment earlier that the law in environmental law had to be created through legislation because, for the most part, there was a lack of judicial activism through the courts to do that. And once the legislation has been enacted and the executive functions have been determined, it's now back to the courts to interpret those things and clarify through the common law. But the point I guess I'm making is that through the implementation of policy, the governments have introduced the legislation which has created the law. And you might think, well, doesn't that always happen? The answer is no, it doesn't. For example, in studying law, we talk about some common law subjects. For example, I mentioned the law of torts, T-O-R-T-S, or the topic of torts, and that covers a whole range of different common law areas of practice. They were common law because the law was established initially through the courts and through judicial activism. And they were in some ways interpreted and changed and modified through later legislation, but they came about as a result of courts law rather than legislation in the first instance. Environmental law is not in that category. Environmental law came about or is coming about progressively through the introduction of statutes primarily. All right.
Yes. But I was just reading the book today, and I've come across that there is a lot of tort mentioned in the principles of nuisance for land.
I'm sorry, Lawrence. It's breaking up.
Okay. I was reading the book today, and there was a lot of information about nuisance for land and trespass for land with different fumes. Yes. And that's tort, isn't it?
Tort. Yes. Nuisance and trespass, at least in the civil sense, is torts law. Exactly. Thank you. All right. Well, look, before I wrap up, I just want to talk about 2.26, which is non-government organisations, and that's on page 34 through to page 35. Bates makes the following comment. NGOs perform important functions in relation to policy formulation, implementation and enforcement. the Humane Society International Incorporated instituted its own enforcement proceedings on whaling, embodied in the Environment Protection and Biodiversity Conservation Act 1999, EPBCA, when the federal government was unwilling to enforce its own prohibitions. NGOs have coordinated protests through the Franklin Dams in the 1980s to the Lockgate Alliance in opposition to coal seam gas and coal mining. The alliance succeeded in gaining a moratorium on new approvals. I mentioned last week, and I mention again, the Community Litigants Handbook, which is, in my view, an excellent publication produced by the Environmental Defenders Office of Queensland. I commend that publication to you, and also recommend that you take time to look at the Environmental Defenders Office website, which is interesting and instructive. All right, now we have one chat comment. Now, this is a while ago. Sonia asked, do short, sharp sentences require a high degree of legalese when writing assignments in the exam? Thank you, Sonia. When we talk about legalese, we're really talking about something which we're, as lawyers, as a profession, we're trying to get rid of. Legalese is the use of complicated, officious terms which are designed in many ways to confuse others. In the use of Latin, for example, is a form of legalese, and having the terribly long sentences, notwithstanding hereinafter, herein before, those sorts of words, is all what we call legalese. So we're trying to stamp that out. We're trying to make the sentences short and readable and interesting. Now, I'm not saying that every sentence has to be short, but I think what we need to do is avoid long, rambling sentences that seem to turn around on each other, if you know what I mean. So I hope that assists you, Sonia, with that query. All right. Well, I think we're just about ready to wrap it up for this week. Next week, we've got...
John, can I just ask you a question?
Yes, Lawrence.
Yes, Lawrence. You know, with those activities, are you able to, like, put up activities of your own so that we can work them out? Or
yeah, sure. Yeah, sure. I'll look at doing that.
I'll look at doing
it. Thank you.
Thank you.
All right. Any questions? Comments? Okay. Well, that being the case, I might stop the recording. Yes, Nicole?
Oh, you'll probably want to stop the recording after this anyway. So the native title and the common law, and I realise that this is really complex and long and difficult, and it's got a whole lot of... My issue there, and I guess I'm struggling to even know how to phrase the question.
Mm-hmm.
The two different definitions and uses of the land are completely different paradigms. So I can't see how common law can ever accommodate for native title.
Okay. Well, actually, common law... Does
that make any sort of sense?
Yeah. See if I've got this right. Common law actually, in a sense, created native title rather than accommodate it through the Mabo decision, which was the genesis of, if you like, modern native title law. The High Court firstly dispelled the notion of terra nullius, and secondly, in a sense, created through that decision the notion of native title. The Commonwealth government, the year later, introduced and passed the Native Title Act, which in many ways superseded Mabo, but the common law created native title, and that's an exception to what I've otherwise been saying in environmental law, where it's generally, one might say, a product of legislation rather than common law.
Okay, yep.
Have I confused you?
I guess, yeah, a little bit. I guess what I'm trying to get at is, so common law is, you know, it's concerned with the rights of usually individuals, but in some cases companies or whatever, over that block of land, whereas, you know, Indigenous belief is that no one actually owns the land. So I can't see how common law can contribute to that thought process of Aboriginal nations.
Now, these are really good questions, thank you. But I think we are probably confusing some concepts. So I'll just see if I can break it down a little. In essence, when we talk about common law, all we're really doing is talking about that branch of the law that was created by the judges as opposed to the Parliament. And that's all we really mean by common law. Another way of describing common law is judge-made law. So in 1990, let's say, there was no law regarding native title. It didn't exist. We had no legislation, there was no acts of Parliament that created it. The Queensland government introduced its own legislation to try to clarify an issue in relation to the Murray Islands. Mabo then took that to the court, it went to the High Court, and in Mabo number 2, the High Court made a declaration to state that essentially native title does exist, and it exists not only for Mabo but anyone that fits within that particular category of individuals. And in doing so, it said that Terra nullius didn't exist. So in 1990, we have no native title law. In 1992, following the High Court decision, suddenly we do have native title law. It was created by the judges, and it's therefore common law. In 1993, the Commonwealth Government makes the Native Title Act, and that becomes statutory law, and that will then overtake the common law. Does that help better explain it, Nicole?
Yeah, it does, thanks.
Okay, thank you. All right, now I think we have another chat question. Anthony, if you don't mind if I just read it out. Where would the Murray-Darling water buyback scheme of landowners exist in the property rights conversation? The government paid owners for their water rights for the Murray River. Is that purely political rather than legal? Yes, the answer is more than likely it's political. Certainly from a policy perspective, the government are very mindful of trying to maintain power in a way, and I mean that not unkindly, but they're looking to generate laws that are fair and popular in many ways. And it's very unpopular law to simply take something from people for nothing. And certainly I think in that case the buyback scheme came about as a result of a policy decision. That's not to say it can't become legislation, but what we've established through the common law cases is that where there is no specific legislation to provide compensation, and where there is no specific policy to provide compensation through the executive, then a prospective litigant seeking compensation for failure to obtain a licence is likely to be unsuccessful in that claim, because the courts have held that there is no property in the holding of a licence as such. I hope that's a reasonable summary that makes some sense there.
So what Anthony's saying there is, does that not set a precedent though, even though they were licences that have been purchased back? I realise it's not through the court of law, it's they've come to individual arrangements with each of the landowners in that buyback scheme, but doesn't that, because there's a recognition of loss, doesn't that then set a precedent?
It does. It certainly does set a precedent. However, that's not to say that that precedent can necessarily be enforced by anyone else. So there are precedents that are created, let's say through the courts, which become binding precedents, but there are other instances of precedents that are not binding. Let's take a silly example. If you have two daughters, let's say we'll make them twin daughters, and on one Saturday night, one of them comes to you and says, I want to go to the movies, can you please pay for it? And you do, then are you therefore legally bound to provide the other twin daughter the next Saturday night with payment to go to the movies. There's a precedent, but I'm not sure you're necessarily legally bound. So precedent can be legally binding or not necessarily legally binding. Okay.
You're kidding. Of course you're legally bound. You'll be nagged to death otherwise.
That's true. Well, you see, that might be political pressure rather than legal obligation. No, thank you. All right. Well, look, on that note, we might look at stopping. Next week, we've got week 4, the nature of environmental law. And I think you're required to look at Bates chapters 4 and 6. So please keep up with your reading. Let's see if we can keep up the discussion, which has been very good on Moodle, and ask lots of questions. All right. Thank you very much for participating. I'll stop recording now. Thank you.